Hello, and welcome to Canadian Lawyer TV. With me today is Raymond Wagner, the founder and principal of Wagners Personal Injury Lawyers. Wagners Personal Injury Lawyers recently won Canadian Lawyers' Top Personal Injury Boutiques in Atlantic Canada. Welcome, Raymond.
Thank you, and welcome, and thank you for having this interview today.
Can you tell me a bit about your firm?
Well, our firm, in terms of our history, our firm was formed in 1982. I established a small firm, and it has continued since that time to now. There has been a considerable amount of changes in the firm over those years in terms of what our profile has been, and our size, of course, is considerably larger than myself and one assistant at that time.
Thank you. Can you tell me a bit about your growing business in class actions, medical malpractice, and product liability litigation?
Thank you for that question. We have been, of course, doing personal injury since the early 1980s. It has evolved in terms of the 1990s. We moved into medical malpractice and developed a pretty robust practice in that area, and that continues to be one of our growing areas of practice. In fact, we've hired 2 new lawyers to assist us in their caseload in medical malpractice. In addition, in the early 2000s, when class actions started to become more prevalent to some degree here in Atlantic Canada, we moved into class actions in areas like product liability and pharmaceuticals like OxyContin, products, medical products like right pro-femur hip implants. We've done some areas with respect to privacy. Environmental is, of course, something that we have considerable interest and considerable reputation with respect to doing those type of cases. And of course, abuse cases and the Nova Scotia Home for Colored Children, the Nova Scotia School for the Deaf, and other types of abuse claims.
Thank you, Raymond. Can you tell me a bit about what trends you're seeing in personal injury litigation?
The trends are an interesting question. The reason that this is an interesting question is that there's been a lot of evolution, and with tort reform, or as we call it, tort deform, in terms of tort claims, there has been a movement afoot from the traditional motor vehicle accident, slip and fall type of practice into other areas like institutional abuse, class actions, and medical malpractice. And so you see more of an evolution in that area. One of the other big trends that you see is that historically, especially in rural Nova Scotia, rural New Brunswick, rural Atlantic Canada, you saw that there was a lot of practitioners, single, dual practitioners, maybe small firms that were doing personal injury litigation. As the matters and as the area has become more complex and more costly with respect to the cost of litigation and the delays inherent in the system, a lot of those players have moved out. So there has been a concentration in fewer players who are running bigger practices in that area. Thank you.
Can you tell me a bit about how the court system has adapted during the COVID-19 pandemic?
You know, it was really a challenge when we started in terms of dealing with the court. The court was very reluctant. They shut down. Trials were delayed, put off into the future. And of course, this caused a lot of problems. How that was overcome was in terms of using internet technology like Zoom, Teams, other providers. And in fact, we've done a full trial, where we were present in the courtroom, but our experts who were primarily from Central Canada made their presentations, gave their evidence, were cross-examined on these media. So it's very interesting because in a number of respects, the first being that the cost of bringing an expert, for instance, from Toronto to Halifax out of their practice to testify, it can be considerably expensive. When they can do it in their own office, providing the technology links are appropriate, really saves an awful lot of money. And it's, of course, incredibly efficient in the sense that if there are delays in testimony, one witness takes too much time and then bumps off another witness, that can be rearranged, again, without considerable amount of cost and disruption.
Thank you. Can you tell me a bit about how the COVID-19 pandemic has affected how your firm operates internally?
That was a big shock for us. Of course, at the start, when we had a total shutdown, we had to totally revamp everything that we were doing. So we had to, of course, provide technology within the office to be able to do discoveries and to be able to have mediations and other types of litigation processes, like trials as well. And so that was one big issue. The second is the personnel side. And that is something that has been very interesting. And so we have, and it really varies across the spectrums of our practice. It seems that motor vehicle and slip and fall type of practice is very amenable to working at home. Medical malpractice to a lesser extent. And class actions are really not very amenable to it. And the reason that is because it is a heavily collaborative process. And having people in the office to talk in real time and to deal with issues in real time in these cases is important. So initially we had some people have virtually worked from home. We have one employee, a paralegal, who has been in the office since the 1st of March of 2020 for one day. That's it. And we have others that have been in that want to come to the office and work 4 to 5 days a week. And so now we're going into when things are opening up. A lot of our paralegals can work now, and lawyers as well, from home for at least 1 day a week, and maybe more depending on their circumstances. While something like class actions, we like to have, we insist actually that our paralegals and our lawyers are in the office 4 out of 5 days at a minimum.
The COVID pandemic has affected the availability of jury trials. How has that played out for you and your clients in Atlantic Canada?
Well, interesting enough, we did actually do a jury trial in last November in Cape Breton in Sydney, and where the jury was selected in Center 200, which is the hockey rink that is used for the Cape Breton Screaming Eagles. And so that's where the jury selection was, and they had special facilities to do the trial of 7 jurors, and of course all the witnesses that were there, as well as the use of technology to testify. So not only have we done a medical malpractice case in front of a judge alone that I spoke of earlier, but also we were able to do a jury trial in medical malpractice case during the COVID crisis. But the problem is that things open up and then they close down. And so we were lucky to be able to do that because those trials took place and were scheduled in the open periods.
Thank you, Ray. Can you tell me a bit about the importance to you and your firm in moving the law forward?
Well, for us, it's a very important question. When we look at cases, we look at, is there something that we can do other than the traditional get compensation for the client? What is the underlying story that relates to this particular case? And what I mean by that is in terms of helping people that can't help themselves in class actions like the Nova Scotia Home for Colored Children. That litigation never would have took 16 years to settle. That never would have taken place if one individual had to bring it or a group of individuals because of the sheer cost and the time and the legal costs. Interesting in medical malpractice is one area that we use a lot with respect to public engagement. And what I mean by that is that when we look at a case, it's not only valuing the case, but also valuing its impact to society, how it can affect those people that may come to similar circumstances as we go forward. How can we change practices? And we have one where our case through the public exposure and it changed the method by which pathology tests were made in terms of the hospital, the tertiary hospital here, the QE2. They had a paper system, but of course that is prone at times for mistakes. And what happened in this particular case, our client was, her lab test was mixed up with another person who had breast cancer, and she went in and had a mastectomy. But it turned out that it wasn't her test. So as a result of the public advocacy on that, that system changed and went to a full barcoded electronic system within months of us commencing and dealing with that in the public domain with the assistance of our client. Another example of that is Robin McGee, who has suffered, unfortunately, from colorectal cancer, from failure to diagnose over a course of a 2.5-year period. She ended up with stage 4 colorectal cancer. She became an advocate on the basis of having physicians and general practitioners, family practitioners, have a protocol, how to deal with symptomology that could relate to colorectal cancer. And so that then became a guidelines that were given to all family practitioners in Nova Scotia with respect to dealing with colorectal cancer and the symptomology.
What does winning this award mean to you?
Well, it is an interesting question. The award is important to us because our practice is really a very collaborative practice. And so to some degree, I'm the face and the name of the practice because I've been here for 41 years. And that's just a default to age. But we really are a collaborative practice. Every product that we deliver is a team effort. We do not have lawyers with a dedicated staff person. We have groups of paralegals with groups of lawyers, and we work collaboratively on every case. And so the success of our firm is really our collaborative success, our ability to work together in a collaborative way to get the best possible outcome for our clients.
That concludes this episode of Canadian Lawyer TV. Thank you for watching.